I want to get to particular types of questions that attorneys will often use as part of their strategy. The yes-no question. That can be very difficult to deal with because the attorney's strategy is to box you in, to force you to a yes-no answer without additional explanation. So the issue you have is, what if you can't really answer yes or no without, being able to respond to the question? That there are, issues that need to be discussed. How do you handle that type of question? Let me start with Shannon this time. You get a yes-no question from an attorney, and they'll preface their question. Shannon, I'm going to ask you the following question. Just please answer yes or no. You get the question, and you're sitting there thinking, how do I answer that? It's not a simple yes-no response. There are additional considerations. How do you deal with that?
So I actually had this happen very recently and started out answering, kind of like you're saying. There are facts and circumstances that need to be expressed in order to answer your question accurately, but he's objecting, that I'm not responsive. And the judge said, say yes or no and then explain. So it's kind of like...
Oh, you got a nice judge, because typically the judge will say what? Answer the question.
Yes.
And what else? You'll get your chance on redirect.
There was also a time in that same testimony that I looked at the judge and said, may I explain? And he said, please. I think he was getting a little irritated, frankly. With
you got a nice judge.
I did. And that really goes to something else for people that are just getting into this. Before I testify for a new judge, I sit down with the attorney that hired me and say, tell me about the judge. Because things can go so differently.
We didn't touch on this, but what you just mentioned should be part of your planning for the trial. I personally like to go into the courtroom before anybody else is in there, and I go up to the stand, make sure I know where the mic is, because I learned the hard way one time setting my papers. It had a mic built into the stand, and I'm shoving my papers across and all this stacks come across. Is there a step up to the stand? You don't want to trip going in. I mean, those kind of simple things, know the lay of the land, I guess is what I'm trying to say, and do your background research on the opposing attorney, on the judge. Where did they go to school? Is the judge experienced? Is he new to the bench? Does he understand this stuff? Those are all really helpful considerations. That's a little bit of a tangential issue, but we didn't have slides on that particular topic, and when you said that, it just really struck a chord with me.
But I do agree with you. It's more common to salvage the situation where you have to answer yes or no in the redirect.
Okay. Miles?
Yeah. My favorite thing is when the expert witness says yes, but, and then pauses. Looks at the judge, dramatic pause, and then hammers the crap out of the lawyer on the cross-examination.
But what if the attorney says, stop there, Mr. Yeanoplos, I asked you to answer a yes-no question. You answered my question. Let's move on.
Yeah, and
that's typically what will happen.
But with the drama of a yes, but, you put a pin on it and come back with on redirect.
Miles just hit the nail on the head. Even if you can't get your explanation in at that point in time, what have you done? You've alerted your client's attorney to make sure to come back on redirect and revisit that question to give you an opportunity to address it in full. Okay, so that's an effective technique. Kevin, thoughts to add?
So what's the takeaway? The takeaway is to make sure some way, somehow, that everybody in that courtroom knows that you can't answer that yes or no without it being misleading.
Yeah.
Follow up on that point.
And the other thing is, if I am absolutely forced to answer it yes or no, I will answer it in such a way, I'll pick the one that I feel is the least misleading. And I'll answer it. And by that point, I've already signaled to the council I'm working with to get me on redirect.
Again, probably for the less experienced folks, just simply saying yes, but, and then if you're cut off by the judge or the opposing attorney, you've at least alerted your counsel.
Yep.
For the more experienced attorneys, for the more experienced experts, if you're comfortable doing this, you could look to the judge and say, Your Honor, I swore to tell the truth, the whole truth, and nothing but the truth, and I can't do that with a simple yes or no.
Exactly.
Now, you better be comfortable saying that, because you're probably going to get a rejection, first of all, from the attorney, and the judge is going to look at you, and if it's a nice judge, you might, like Shannon had, he might say, well, okay, I'll let you explain. Or he may just look at you and say, answer yes or no. Your attorney will have an opportunity on redirect, and we'll come back to this. So,
I like mentioning the misleading. What you just said is great. It could come off as being a smart ass.
as I said, you better be experienced, and you better know what you're doing and comfortable doing it. I would not do that as a novice.
And again, I don't think we said this explicitly, but the jurisdiction you're in is extremely important, and the judges, because more times than not, every jurisdiction I've ever testified in, the judge doesn't want to get overturned on appeal.
Right.
So they will bend over backwards in the interest of getting more information than less information.
And particularly in a bench trial, okay, where, the judge will typically say, I'm going to be deciding this, I'll weigh the evidence, go ahead.
Right.
You have more latitude in a bench trial than you would in a jury trial.
That's kind of why they allow calculations now. The judges will
Stop.
allow it
Stop. We're gonna
and
talk
give
about
it
this.
appropriate weight.
We're going to talk about this in a minute. All right, next question.